Hello, Jacob. How are you?
I'm well, Maya. How are you?
I'm fine, thank you. Happy to see you. And thank you for being my guest today for this interview. And I'm going to start by asking you, Jacob, to introduce yourself to our listeners and viewers.
Well, it's an honor to be with you. I listen to this podcast. I think I've heard every episode. So
Thank
to
you.
be on the same podcast as some of the other incredible guests that you have, I don't feel I'm worthy of this honor, but I do very much appreciate the opportunity to be on with you. To introduce myself, I am a fourth year criminal defense lawyer at Lockyer Zaduk Z. I think when this episode airs, I'll be in my first or second week at the new firm. Before then, I practiced for just over 3 years as an associate at Robichaux's and handled uh, all sorts of criminal offenses. I'd say most of my practice was in defending sexual assault allegations, but we took on files ranging from the least to most serious criminal offenses in the code.
All right. And you're based in Toronto. For those who don't know these firms, this is all in the Toronto area.
That's
Okay,
right.
Jacob. So you are what we consider a recent call. You've been practicing for 4 years now. And one thing that you will be talking to us about is some of the challenges that recent calls are facing these days, because there are a lot of difficulties right now in the practice of criminal law, in addition to the ones that everybody's facing, legal aid, and although there is a raise now, so there should be some improvement there. And the fact that a lot of lawyers are leaving the criminal defense bar for various reasons, work-life balance and money and other such reasons. Recent calls have their own issues and difficulties and challenges that they have to deal with. And so maybe you can tell us, as someone who's a recent call, what are some of the challenges that you guys are now facing and that you can maybe tell us about how your experience was in those types of situations?
The most obvious challenge for me was being taken seriously by the Crown or
Mhm.
the crowns that I worked with. I remember on the first trial I did on my own, I got the impression that some of the resolution offers that I was receiving from the Crown were not all that serious and were the Crown trying to see if I knew what I was talking about and to quickly get a case off their plate. Uh, I think the way to overcome that, or at least the way for me to overcome it, is to know your facts really, really well. Everybody expects, even of new calls, that you're going to know the law that applies to you, applies to your case rather. To me, what distinguishes the good from great lawyers, and I certainly don't consider myself to be in the latter category, but what I've noticed in the great lawyers is just how well they know the facts of their case. They know them inside and out, and they know them better than the Crown can know them because the Crown just doesn't have that much time to devote to a particular file. So I think if you show up at a litigation and you know your case every possible way, you gain a lot of credibility, not just before the court and the judge you're appearing in front of, but you gain credibility with the Crown, and the Crown that you're working with realizes that uh, they they're dealing with someone who knows what they're doing. And for me, that went a long way. I don't know if everyone else has had the same experience, but it, in my first few solo litigations, demonstrating to the Crown that I knew what I was doing and I knew the case helped me gain credibility, not just with them, but with the judge. The other thing that I've found uh, challenging is I find that we have a very conservative tendency as lawyers, and especially as a new call, I was always very mindful of not overselling the strength of the defense case to a client. And I think I was too mindful of that and was too risk averse to the point that I was not conveying to the client early in my practice just how strong some defense cases were. And what I mean by that is, I think sometimes cases that go to trial are just really weak for the Crown, and the Crown pursues them for various reasons. I know some of them are policy
Mhm.
reasons. And what I was really afraid of doing was telling a client, I think the Crown has a terrible case, and the most likely outcome is that you are going to be acquitted at trial. And instead, I was so focused on under promising and over delivering that I wasn't giving clients a perfect or fully candid assessment of their case. And what I learned through my mentor, Sean, and with more experience is you can tell a client that you think they have a very compelling case. And it's important to tell the client that because it affects their decision on possible resolution offers, and they just need to know, in your view, what the risks are of going to trial and how likely you think those risks are. So I think one thing that I struggled with, but I hope I've gotten better at, is not worrying too much when I convey to a client that I think their case is strong, that something unlikely will happen, which it always can,
Mhm.
and they will lose. And I've found that I've gotten a lot better at having those discussions with clients.
Okay, and that of course also comes with experience, right? The more experience you are with the practice of criminal law, the more confident you feel about your ability to actually also win a trial. I mean, that will increase your chances. But speaking of clients, though, that's also another issue that many new lawyers struggle with. And it's how do you convey that confidence to a client when you're a new lawyer? And a question that many new lawyers ask is, well, do you tell them your year of call? Do you tell them that you don't have enough experience? And how do you deal with that? And even when you do disclose that information, how do you still keep the client, um, let's say, how can you still gain the client's confidence and trust and want them to still retain you despite the fact that you may not be the most experienced lawyer?
I was really lucky in working with Sean
Mm-hmm.
for 3 years. Early on in my practice, when I was struggling with the issues that I just mentioned, Sean would be in those meetings, and Sean would give me the opportunity to provide the client with an assessment of the case, to communicate with the client about the next steps, about the strategy. And from there, Sean would fill in the blanks with his views and information that he thought the client needed to know. So when I was just starting out, it was unbelievably helpful to have a mentor with me during those meetings
Mm-hmm.
and also after the meetings to debrief the conversation we had with the client. And Sean would tell me things that I could have done better and things that I did well. So that was very, very helpful. When I started speaking with clients on my own,
Yes.
especially during the initial intake process, I would tell clients my year of call. I would tell them what my experience level was.
Mm-hmm.
And I would explain to them that on any of the files that I was doing, there was always an option to have a senior lawyer working with me. Uh, Not all clients took that option because I think after I gained some experience, they appreciated that I at least sounded like I knew what I was talking about. And there's also a cost element to it. With private retainers, my hourly rate is obviously lower than the hourly rate of a senior lawyer.
Yes.
That's one selling point for
Yeah.
clients. These matters
And it's
so
something that a lot of clients are looking for, right? Like they don't want to spend too much money on legal fees. And so that's really one big advantage that a newer lawyer has over a more senior lawyer.
and let's be honest, if money were no object, I do not think that as a new call, I would be the first choice for somebody to hire. If I was in my second year of practice, I just basically just started, and somebody could hire me or hire
Your
James
mentor. Yeah.
or Sean
Yeah.
or Marie Hennon. If money were no object, I'm not going to be the one that they hire. But I do think that telling the client or the prospective client what your year of call is, what your experience is, what your expertise are, that does build trust. And I don't think that I should hide that from the client or
Hmm.
the prospective client. To me, they're entitled to know that this is about them. They're the ones who are facing what might be, or is in many cases likely to be, the worst experience of their lives. And they are the ones who are at risk of losing their liberty. So I think that I owe it to them to explain what my experience is. And if they want somebody more experienced, I don't take that personally. That makes complete sense to me. But
And
I always
yeah,
did tell.
no, go ahead. Sorry.
Oh, that's all.
Because I wanted to add here, I mean, it has been my experience when I was in my first couple of years of practice that, I would get that question, like, how long have you been practicing? And I always told them, like, I'm a new lawyer. And surprisingly, many clients actually like that. There are some clients who want the newer lawyer, who I had some clients who did tell me that they didn't feel comfortable going with someone who's more like senior, older, and who didn't have as much time. So some of them actually like that because that's also another advantage that a recent call has is that you don't have as many files. You're not as busy as the more senior ones. So you have more time to devote to your clients. So, and the clients will see that. They will see that, they will feel that. And that's also a big advantage also that recent calls may have over senior lawyers. So, and then how about the bench? Because so we talked about crowns, we talked about clients, but what about the bench? Now, with the bench, some judges do realize right away that someone seems to be new and they will automatically be nicer. And sometimes some judges are just like, well, we don't have time. It's a busy court, so we don't have time for a new call. So, how do you, what are some of the challenges you faced with the bench as a recent call?
The bench has been phenomenal to
Yeah.
me. I haven't had any bad experiences with judges or any experiences that have made me feel a judge has treated me unfairly. Some judges are more difficult to appear before than others. That's not because they're being unfair. It's because
Yeah.
either they ask very challenging questions, or when you're making submissions, they sit there with a poker face and you have absolutely no idea what they're
Yeah.
thinking. They've
Yeah.
tuned out. Uh, but the bench has been great. I say that recognizing that I am a white man, and I'm sure that my experience is not the same as others have been in front of the bench, but all of my experiences in front of judges have been very positive. I think that for recent calls and those who are less experienced than now I am, one way to have those positive experiences to control as much as possible the experience you have before judges is just to make sure you're really prepared. If you're in the superior court, use case lines, upload things to case lines on time, hyperlink your materials. There's one judge in Brampton who I think she's one of my favorite judges to appear before. And if you don't hyperlink your materials on case lines, I I think you'll get a bench warrant. Uh, so just be really, really prepared. Uh, Make sure you know the facts of your case inside and out, and you'll gain a lot of credibility before the court. And that's something I've noticed, not just from my experience, but in watching senior lawyers appear before the court. I've seen some senior lawyers who show up unprepared, none that I've worked with. They've showed up unprepared, and judges have been ready to jump down from the bench and shake them. And I've seen uh, lawyers who are unbelievably prepared, not just senior, but at all levels. And those lawyers tend to get, I think, more respect and to have more credibility in front of the judges that they appear before.
Yes, and so I mean, preparation is the key in all of that, whether it's dealing with the crowns for the first time and they don't know you or the bench. It's like preparation is always very important for everything and including for clients. Now, Jacob, I also wanted to ask you in terms of um, the criminal justice system. So, as a recent call, what are some of the issues that you see or that you are aware that your colleagues, new lawyers, are also facing that you think that you wish was a bit different, that would make life easier for a criminal defense lawyer? So, from a recent call perspective.
From a I actually haven't thought about this from a recent call perspective. I've thought of it more from a macro perspective.
Well, let's start with macro and then maybe
Okay,
let's see
sure.
from a recent call perspective.
From a macro perspective, there are the obvious. Legal aid is
Yeah,
underfunded. More judges need to be appointed because of how overburdened our criminal justice system is. I think we're putting too many people in jail. Those are all problems with the justice system that I think we talk about all the time. One that I don't hear talked about as much, Maya, is the I think we need in Ontario better crown screening and
hmm
to give to empower individual crowns and give them more discretion to pull cases that they're never going to obtain a conviction on. And there are lots of those cases that go to trial. And
Yeah,
as I said earlier, I think they go to trial because the individual crowns are constrained by various policy reasons that require them to take those matters to trial without a
yeah,
plea. In my view, if the individual crowns had more discretion and they weren't so constrained by public policy or input from complainants, the system wouldn't be as overburdened as it is. But unfortunately, the number of trials that I have run that going into it, not only I, but judicial pretrial judges have told the Crown, you're never going to win this case,
yeah,
is too high. And relatedly, I do take some issue with in cases that are lacking, rather than the Crown simply withdrawing. One change I'd like to see is, uh, put it differently, I'd like to see the Crown not insisting on peace bonds or pleas with absolute discharges to lesser offenses for withdrawals. I think what happens in a lot of these cases that lack a reasonable prospect of conviction is Crowns still insist on a resolution that jeopardizes the accused person's interest, whether at the border or through employment or for it. I think that's a big problem, especially with peace
yeah.
bonds. To me, if there's no reasonable prospect of conviction, I think the Crown should be empowered to just say we're pulling this case and not insisting on any court orders or any pleas. So that's just one thing that I would like to see changed in the justice system, amongst many others.
And how have you been finding the because I mean one of the things that many recent calls do, especially when they're associates in a firm, they do a lot of the pleas, the sentencing, a lot of bail hearings, a lot of assignment courts and adjournments. Um, but the challenge here for many of putting the sentencing aside, many of the challenges that we have is how quickly everything has to happen, right? Because of delays in 11B. So there's always this pressure to always do things quickly. And so sometimes that can be challenging for a recent call, right? When you're new and you're still not very comfortable and you have to have that CPT very quickly and very early on, you have to have that JPT. So how have you been finding that? What was your experience with that, with the rhythm of the criminal justice system for a new call?
My experience has been the opposite.
Okay.
Maybe it's because I started in 2021, which
Hmm.
is when everything was so backlogged
Yeah.
because of the pandemic. But my experience has been I've wanted to move things along, and it's taking months to get disclosed,
Okay.
taking months to get a response from the Crown. One of the first trials that I did, it took about 6 months to get disclosure on a sexual assault, and the core disclosure was just the complainant's statement to the police. It was about
Oh,
an hour
after
statement.
2 months,
6 months.
6 months, sorry.
6 months to get a complainant's statement of the police. That was about an hour. And I would continue writing to the Crown, and they would say, "We don't have it. The police haven't sent it to us." And that is more typical of my experience. That's certainly on the high end, but my experience has been I have tried to move matters along, but the Crown and the police are, I guess, overburdened or not as quick as I would have liked them to be. And the challenge there as a new call has been balancing the client's right to a trial within a reasonable time, being diligent, as the Supreme Court in Jordan
Yeah.
instructs us to do, but not being overzealous and emailing the Crown or calling the Crown every day. That I found early in my practice, and I know I'm still early, but very early in my practice, I think I was a little bit overzealous and sending one too many emails to the Crown to move the matter along. And now I've learned to back off doing that and to not be
Hmm.
fine. But I haven't really had the experience of I need to move this along so quickly, and I feel overwhelmed as a result because I've found the pace at which things have moved on my files has been dictated by the delay in the system.
And the system. And this is one thing that I also have noticed in my practice, and one thing that I tell my clients about is that the rhythm of the criminal justice system, even though it's supposed to, things are supposed to move quickly, they don't happen at the rhythm that you would like things to happen. So it's never going to go as fast as you want it to be. And so this is also some of the things to manage clients' expectations, to let them know in advance that it's going to take some time, even though you have a right to a trial within a reasonable time. It's still not going to be as fast as they wanted to be. Jacob, so are there any other um, points or any other problems or issues as a recent call that you would like to tell us? Or maybe if there's, I don't know, a particular experience that you would like to share with us that something happened um, that, like maybe early on in your first few years of practice that you can share that could be a good lesson for the recent calls we're watching.
Sure. I'll share two. I don't think the first one will be that much of a lesson, but it's a
Okay.
peeve of mine. In some jurisdictions for case management court, set date court, as some call it, we're still using the Barristers Act. And I know
Mhm.
the Barristers Act doesn't even say this, but you are supposed to appear for a 9 o'clock appearance, and the order that counsel is called goes
Yeah.
by year of seniority. And you get some lawyers there who were called many years ago and have 97 files.
Hmm.
It's difficult to know when to log into these courts.
Hmm.
So I I do much prefer the practice of a sign up list, and that gives you some predictability about when the Crown
Yeah.
or the court will call your matter. So for new calls, be aware that in many jurisdictions, if you have a 9 o'clock appearance, you might still be there at 11:30 a.m.
Yeah.
even you will speak for maybe 20 seconds on the file. One thing I learned was helpful in this respect was for a lot of first appearances, I've started using enhanced designations, and I don't think they're talked about very often. For those who don't know what those are, it allows you it allows the matter to be heard without counsel or the accused attending,
Yeah.
and file is automatically adjourned for 12 weeks. I find those helpful for first appearances because realistically, all that's going to happen at the first appearance is you're going to say, we're waiting on disclosure or we just received it. And there's no reason for you in most cases to incur hundreds of or thousands of dollars of fees for a client to sit in case management court and say a few words. So I think clients do appreciate that enhanced designation. Sometimes I've used an enhanced designation. The matters moved along more quickly than I thought it would, and just use a I just bring the matter forward if necessary. That's pretty rare, and I've found the enhanced designations have been a good way to reduce time sitting around in very busy courts, waiting for all the more senior calls to be heard. So that's one thing. The second,
But before you talk about the second thing, I just wanted to ask you a question, just out of curiosity. I mean, I've initially tried a few enhanced designations, and my experience was that they never made it to court. So every time I filed them, there was always this response from the court: we haven't received the enhanced designation. For some reason, they would receive the ordinary one, but not the enhanced one. So have you been having this issue as well, or it seems like it's going well with the enhanced designation for you?
I don't file an ordinary designation at the same time as an enhanced designation.
Right. Yeah.
The
It's
enhanced one.
either or.
And I also won't do it for a client if their first appearance is coming up soon.
Hmm.
If their appearance is in some time, I will wait. I won't wait. I'll file it right away and I'll ask for a response from the court. I'll
Hmm.
also call the court to make sure that they have it. And then closer to the appearance, I reach out to the court again just to make sure it's attached. And I haven't had a problem with that, but unless I get double or triple confirmation from the court that the
Okay.
information is there, then I won't rely on it. And I also won't rely on it in some jurisdictions because I know some jurisdictions are more reliable than others with getting uh, paperwork where it needs to be.
Okay. So going back then to the other experience that you wanted to share.
Sure. The other embarrassing experience, and it
Mhm.
was an embarrassing experience, is I was doing submissions on a sentencing on a homicide trial in the Superior Court of Justice. Uh, Thankfully, the issue on sentencing that I was dealing with was an academic one and it
Okay.
not practically impact
Yeah.
our client, but it was a complex issue. The Crown and I went back and forth on figuring out how we were going to resolve it. And then we got to court, and I was confused by what the Crown was saying. And my submissions before rather senior, very well respected judge were terrible.
Okay.
The judge asked me what my client's birthday was. It was written at the top of my page. I had no idea. I was totally flustered at that point, and I was quite embarrassed. I was very fortunate, though, to have a phenomenal mentor and Sean with
Hmm.
me. And the way I approached it was I just asked if I could have a brief recess. The judge said no problem. Sean and I spoke in the hall, and he gave me some advice on how to handle the situation. And I came back and dealt dealt with it apologized to the court for my confusion, and it was fine. I was, again, really lucky to have a mentor to help me in that situation. But I think the takeaway for me there was, as long as you're not being gratuitous, if you need a few minutes, ask the court for a few minutes. And maybe there's a few judges out there who will say no. But I think the vast, vast, vast majority of judges, if they see, especially as a new call, that you might be struggling with an issue, and even if you don't have a mentor there, if you want to give a call to senior counsel to ask for their perspective on an issue, I don't see anything wrong than that. And that that to me is a good example of a piece of advice that I would give to people just starting out,
Yeah.
and that I received, which is, this isn't about you, this as the lawyer. This is about your client, and you can't let your ego or your pride get in the way of that. If you make a mistake, own it. If you're confused by something, even if you don't think you should be confused by something and you find it embarrassing, own it, deal with it, figure out how to approach it in the right way.
Mhm.
But you need to have humility in those situations and not try to wiggle your way out of something that might make you look bad. I think you need to approach that head on. And that was one of the most important pieces of advice that I received very early on. And that was, this is not about you. This is about your client. So that was an embarrassing situation. Asking for a break 5 to 10 minutes into your submissions, that was embarrassing. I obviously didn't want that to happen.
Mhm.
I'm glad that I did, though, because it would have just gotten worse. I would have dug a bigger hole for myself if I hadn't done that. And having received the advice before that experience of, this isn't about you, this is about your client, and you need to do everything you can for your client within reason, that was really, really helpful advice that I got early in my career that I applied to an embarrassing situation.
And judges, they do also feel. I mean, they notice. They can tell, like, if a lawyer needs some time or needs to ask for advice. They will see that, and they'll never say no. You're not allowed to go and get advice. Like, I don't think any judge is going to say that. So, on the opposite, I mean, they will give you the break, and they will understand, and they will have a sense of what's going on sometimes. And even if they don't, if you ask and you tell them or you explain in a subtle way, I just need to, speak to a colleague or to a more senior lawyer, they will always allow you that. No, I don't think any judge is going to say no to that. So
I hope
that's
not.
yeah, no, I don't think so. But I mean, like, I think the issue is more on the side of the recent call, is that sometimes it's the new lawyer who feels shy or embarrassed to ask for that. But don't, because they will give you that time. But if you don't ask for it, you won't get it. So I think it's good and important to let them know that, and the thing is, the reality, Jacob, is that it's not something that happens only for recent calls. You can have more experience and still encounter a situation in court that you don't really know how to deal with, and you need to talk to someone, you need to ask someone else. So it's valid advice to anyone, not just a recent call. So I don't know if you have anything more to add on that, or if you want to share also more about some of your experiences as a recent call, or other of the challenges that we didn't cover from a recent call perspective.
Sure, I have nothing more to add on that. I hope that this podcast is helpful for recent calls. And if there's one piece of advice that I could give to recent calls that I wish I knew earlier in my career, it would be on the importance of listening. I went to law school thinking, and I started practicing thinking, law is just about talking. It's about a great cross-examination, great submissions. And if you're just really good at talking, you're going to have no difficulty in this profession. And of course, talking is important. It's a big part of what we do for a living. But what I didn't realize until I started practicing was the importance of listening and
Mhm.
actively listening. And if you go into court, in most cases, thinking you know everything that's going to happen and this is your plan because you're just so certain about what a witness is going to say or what witnesses are going to say, there's a good chance you're setting yourself up for failure or for difficulties that you don't need to experience. And sometimes witnesses for the crown will say things that are really helpful for you.
Yeah.
Sometimes the case will change dramatically in your
Yes.
favor with 5 words. And if you're not
Or
listening,
or what they don't say, right? Like sometimes they won't say something important that they said in their statement, and that ends up being good for you.
exactly. And if you're not listening to what that
Yeah.
witness is saying, and you're just there ready to get up and do the cross examination that you prepared, you might miss that gold. And as I said, you might be stunned at the direction that your case goes after a witness takes the stand.
Yeah.
I think in some types of files, you should be even less stunned about that because the police statements that we receive are so sparse. There are no preliminary inquiries. So you don't actually know that much about what the witness is going to say. And really listening to what's happening in the courtroom is so much more important than I ever could have imagined. And
Yeah.
similarly, listening to your clients is unbelievably important.
That's very true.
Clients generally don't know the law very well. That's why they come to you.
Yeah.
And they might give you 100 ideas that don't make sense, that you can't pursue. And it's not because they are uh, there's anything wrong with them. They just don't know how the system works, and the rules of evidence are not intuitive, and especially in sexual assault matters.
Yeah.
But if you start tuning the client out because they've given you 100 ideas and you had to dismiss all those ideas as being unhelpful or telling them you can't do it because it would violate some rule of evidence. If you tune them out, that 101st idea might actually be really helpful. So what I've learned over time is to make sure you listen to your clients very carefully. I think you owe it to your clients to listen to them. And if you don't, you run the risk of not pursuing something because you've just started treating them dismissively. So whether it's in the courtroom or in meeting with clients or even in Crown resolution discussions, it's so important to listen to what your clients are saying or to listen to what's happening around you. Relatedly, one practice that I've found very helpful is for long trials, especially, you can, as counsel, use a recording device in the courtroom
Mhm.
with the judge's permission. Most judges do not know that this is a thing, and you need to direct them to the practice directions or to Section 136 of the Courts of Justice Act. It is so helpful to have that recording and listen to it on the way home, listen to it in the evening as you're preparing for the next day. Because even though you might be listening very attentively in court, there might be a few subtle things that on a second listen, you hear and you think you might be able to explore. So I couldn't recommend more highly using a recording device with the judge's permission. Not a very well-known practice, but one that has been very, very useful to me.
Okay. And just going back on the point that you made about listening and how important it is a very important point to listen, especially to clients, I find, because even though it is true that sometimes clients will say a lot of things that are not necessarily relevant or that won't really change much in the case, they will sometimes make some really good points because at the end of the day, the clients are the ones who were there when the incident took place. So they're the number one person who knows what happens and who can give you a feeling of what was going on. And so listening to clients is important, but of course, I mean, it doesn't mean that you have to follow everything that they say, in the sense that at the end of the day, you apply the law, you know the law, and you have to guide them and say how the law applies in that specific context. But you may be missing out on a lot of important information if you don't listen to what the client has to say. So this is really some very good advice, Jacob, for recent calls. And like you said, listening is just as important, if not more important, than actually talking as a lawyer and making all these submissions. You need to also listen to what is being said. So I want to thank you so much for taking the time today to chat with me, to share some of your experience, and to give tips to recent calls. And I'm sure that this is going to be very helpful.
I hope so. And I thank you so much again, Maya, for having me. It was a great honor to be on with you.
It was my pleasure. Thank you so much, Jacob, and good luck with everything.
Thank you.